All rise. The Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable William D. Palmer, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Orfinger. To my left is Judge Evander. We have 4 cases on the docket today. There'll be a panel change after the 3rd case. They're all civil cases, so each side will have 20 minutes. The appellant can reserve as much time for rebuttal as they like. Just let us know. We'll try and help you keep track of that. We will take a break after the 2nd case. We'll invite the lawyers, if they like, to join us in the Lawyers Lounge for coffee. We also have folks here today from Astronaut High School, and if they would like to join us for the break, they are welcome to do so as well. First case on the docket is John Doe versus City of Palm Bay.
Good morning, Your Honors. My name is Barbara Shepard. First of all, I'd like to reserve 2 minutes for rebuttal, if I could,
2
please.
minutes, did you say?
Yes, sir.
Could you pull the microphone down just a little bit?
Okay.
Thank you.
When the
Okay.
yellow light comes on, that means you're into your rebuttal time.
Gotcha. Okay. My name is Barbara Sheffer. I represent the appellant John Doe, and with me is my co-counsel Cindy DiAugustino. I'm sure the court is aware that what we have at stake here in this 1983 action is a challenge to an ordinance passed by the City of Palm Bay. That ordinance specifically prohibits our client, who is a registered sex offender, from entering a home where there are minor children or vulnerable adults to do his work. He is licensed by the state of Florida to do independent plumbing contracts, and approximately, or he estimated, which was not rebutted in any way, approximately 90% of his business was in the City of Palm Bay. Of the nature of the beast is when he made that inquiry of anyone who was calling to his business for purposes of coming to their home, he would have to inquire, do you have a minor child or a vulnerable adult? The response would be why, and he would have to explain. So even if they didn't have one, he tended to lose the business because of identifying himself that way. Now, obviously, those same people that were making that call, even without that identification, could have easily looked him up on the state sex offender list. So in some ways, this is almost replicative of the advantage that the homeowner would have. At the same time, okay, let's say at the time of passage, okay, as another point that we want to make, by the way, he was put on probation, which presumptively says that he was not dangerous, not apt to reoffend, at least by statutory law in Florida, and his victim was 17 years old, just so we're kind of clear as to where we stood on that. At the time of the passage, there was no actual evidence presented at the hearing that was conducted where the vote was taken in City Council as to the predicate. The predicate was merely announced, and there was nothing outside of that that was presented in relation to any evidence regarding the purpose of the ordinance itself, nor was there any suggestion in deposition testimony from witnesses that we deposed that such evidence actually concretely existed in the way of, if you will, reference to studies and things of that sort.
One of your arguments is that there needs to be some kind of individual determination as to any individual registered sex offender and whether or not they would be dangerous. Is that correct?
That's correct, Your Honor.
Would your argument be the same for other types of restrictions, like being able to live within 1,000 feet of a playground, et cetera? Is it your position that any of those restrictions require an individualized determination in order to be constitutional?
Very well might be, Your Honor, if they are imposed after the fact, if they become a retrospective kind of application. The sex offender registry is a retrospective application. I honestly continue to have difficulty with that with some other clients that I have. But the reality is, if it's a retrospective application, okay, you're on the sex registry, so you can't go near a playground or a park now. If that was not a condition of their plea agreement or their sentence or something of that sort, I would say that based on not case law in Florida, and by the way, we would at least suggest to the court that this case is probably one of first impression in Florida on this kind of a subject. But other states have begun to declare those kind of retroactive, if you will, ordinances or statutes to be unconstitutional, and even with residency requirements, you're grandfathered in if you live there. So, unless it would have that component in it, I would make the same argument, that there needs to be a determination of his dangerousness. As we have presented to the court as well on that subject, since you bring it up, we had an expert that the city deposed who clearly testified that our client is about as dangerous as anybody walking down the streets in Florida or anywhere. He is an expert in the field. He's a psychologist with a PhD. He and his wife have both local, state, and national recognition now in this whole field, and there's a lot of rethinking from the time that we went through the procedures in the 90s when a lot of these statutes began to emerge in here and in other states. There's a lot of rethinking on the part of experts, including on the whole recidivism rate. Recidivism rate, among these people is extremely low. Probably one of the lowest in terms of any kind of criminal behavior for sex offenders. Now, I'm not standing up here in front of this court and arguing about sexual predators. Our subject is focused on sexual offenders such as our gentleman that we're representing.
On your argument about the procedural due process, how do you deal with the case of Connecticut Department of Public Safety versus DOE? Where the Supreme Court said it was unnecessary to have a procedural due process element.
That was really because the court, in the Supreme Court, and of course I can disagree with them too, but the Supreme Court of the United States, I know you can't. The Supreme Court of the United States appears to have done that by determining that registration on the sexual offender registry is a collateral consequence, and therefore civil in nature. We argue this is ex post facto because it's criminal in nature, and it goes much deeper than that because it's actually denying our client employment to which he would otherwise have access to support his family, almost to the tune when we presented our original complaint to the city of about $300,000 in income over a period of time. That's a lot deeper effect than the fact that you're appearing on a website somewhere for the state of Florida. Granted, people may choose to look there, or you may have to fill out an employment application, and depending upon the nature of the employment, it's not unreasonable to believe that an employer may be shy about hiring somebody that's on that registry.
Is your procedural due process argument require that we agree with you on that this is criminal or punitive in nature rather than regulatory?
Yes, and there is a case...
So if that argument fails, then your procedural due process argument fails, but if that argument prevails on the punitive or in nature...
It's tied into that. There's a case that we cited called Doe versus Boston, which obviously comes out of Massachusetts, where sex offenders were prohibited from entering long-term care facilities. And the court in that particular case said, that's very similar to our prohibition. You can't enter a house. You can't go on the curtilage, even to mow the grass in the city of Palm Bay. And ours is very similar to that. The Doe versus Boston case addressed the issue of find out if they're dangerous. At least give them the privilege of that, because that's the whole predicate of the ordinance itself. And our gentleman was never given an opportunity to have that determination made, yet he does have evidence that he could have presented to the court below, had a hearing been had, that he does not fit into this category at all. Okay? The fact that you're on the sex, there's an array of people that are required, depending upon their crime, crime to actually become registered as a sex offender. And as we even know, there's been a lot of controversy over the Romeo and Juliet issue, that the states have had to go back and readdress. So he just simply does not fit into that. So I would say that, yes, without a hearing, there is a direct violation of the procedural due process as given by the Constitution of Florida and the state of, and the United States.
Right, but that assumes that your ex post facto argument prevails and that this is punitive rather than regulatory.
Yeah, well, ex post facto, in a way, yeah, except that, again, I'm not relying on ex post facto per se to argue that, in the sense that the Doe versus Boston case did not get into that environment. Instead, it basically said that there needs to be a hearing before you make to determine dangerousness, before you prohibit somebody from entering a long-term care facility. Simple, flat out, because otherwise you are not offering them procedural due process. Procedural due process, the entry into a long-term care facility as a community resident is not the same thing as having to register on the sex offender list. The entry into a home to do your business that you are licensed by the state to do, okay, clearly, a full license with no restrictions on it, is not the same as having to put your name on a sex registry. So again, one is a collateral consequence, the other is clearly a violation of constitutional rights.
Let me ask you about your licensing argument.
Yes, sir.
You essentially argue that because the state law establishes the licensing requirements for plumbers, that Palm Bay can't overlay other requirements such as the one that this ordinance has.
Let me massage that just a little bit. The state gave John Doe a full license as a plumber. In order to get that license, he had to go through what is essentially a background check. And they could have denied him the license. They knew he was a sex offender. They could have denied his license. They could have probably put a limitation on it of some kind, and they did nothing. And that was after he was on the list, after he committed the crime. So now we have the city coming in and saying, okay, we're going to add another requirement to the licensing process. And we're saying that, no, the state has occupied that whole arena, and they've already done everything that you're talking about. And so we're not just simply saying that they have added a few things in. They've actually contradicted.
Your argument essentially, though, is that because the state established the requirements to be a plumber, the city of Palm Bay can't establish additional requirements.
Correct. Well, that's what I'm saying, that I don't necessarily agree that they are additional requirements. I think they're contradictory requirements. Okay, that's,
Below, you argued that because the sexual predator statute, and I recognize that your client is not a sexual predator,
Correct.
He's a sexual offender. Below, you argue that the sexual predator statute prohibits individuals who are sexual predators from going to hospitals, schools, etc.
Right. Correct.
But the sex offender statute doesn't have a similar requirement.
Correct.
I didn't see that argument made on appeal. Am I reading your brief correctly? I mean, what I saw that your preemption argument was limited to the idea that the state established the requirements to be a plumber, to be a licensed plumber. Your client meets it. They've preempted the field of whatever it takes to be a plumber. If you meet their requirements, Palm Bay can't overlay additional requirements on it.
Okay.
So have I missed it, or?
No, I think we have mentioned the issue of the predators in passing, but I think we did that in relation to the ex post facto argument.
Okay.
Yeah, as opposed to that. We have two of our issues.
Back to the plumbing license issue. Now, I guess the ordinance provides that if you violate it a third time, then
Yes.
your license is subject to revocation.
Right, well, occupational license.
I mean,
Right,
occupational.
not the plumber's license. I don't think they have any authority to
Okay.
go after the plumber's license.
So, On your argument on the preemption, are you saying that it's just that part of the ordinance that's invalid, or the entire ordinance is invalid?
I think that the entire ordinance is invalid because they're putting, again, they're turning around and saying, you're limited. You can't do your work in certain places.
Because he still has a plumbing license, though.
Yeah, the plumber's license, but the state could have put that limitation on them under the statutory authority of licensing him to begin with, and they chose not to do that. And I think the state authority should trump the city's authority. Okay. As far as the equal protection is concerned, we have several cases that we presented to you in relation to, and let me back up. We have two issues that I think would easily allow this court to, again, look at, examine, evaluate, and determine that that this ordinance is just plain unconstitutional, and end the argument there. Okay, that being the preemption and also the ex post facto. Ex post facto we have, I think, thoroughly outlined in our brief and in our reply brief.
Dependent on us determining that it's a criminal statute as
That's
opposed to
correct.
a regulatory
That's the
statute.
equivalent of a criminal statute,
And
correct.
what makes this the equivalent of a criminal statute?
Well, there's a lot of things. Part of it is the fact that, first of all, you see where it's locust. It's under misdemeanors in the city ordinances, okay? It's punished by criminal sanctions, okay? If you violate this ordinance, it's a second-degree misdemeanor once. Second violation, first-degree misdemeanor. So in the sense that it actually does meet the criteria of Kennedy Mendoza, we evaluated the elements in our brief. It's working an affirmative disability on our client, okay? He can't do work in certain places, and as a result has lost, as I said, almost in the neighborhood of 300, at that time, and probably more since then, lost almost $300,000 in income. The direct loss of employment via legislation is considered a punishment. Okay, the cases of Nixon and Lovell both suggest that. And as far as finding, I can go through each of the elements, but again, you have the advantage of that in our brief as to how we see that each of these elements. One of the major elements is that it's excessive. Okay, the court says pay a lot of attention to the seventh element, which is it excessive? And they give great weight to that. There's no consideration of individual risk. It's excessive in that it slaps everybody, regardless of what their background is, regardless of their dangerousness. And again, we have a client here who has been, by a renowned psychologist in this field, declared to be no risk, or the equivalent risk of any one of us walking down the street today. The other thing is that we have, in terms of evidence behind these particular offenders, is this intrafamilial. That's the most prominent type of offense that occurs, where they are either within the family or someone that they know. They're going into homes of strangers. It's not the same, it's not the equivalency at all in terms of, again, plus, in terms of excessiveness, they can't even go on the lawn and cut their grass based on what the city has chosen to do. And I don't really think this court can kind of start to carve up this ordinance and say, well, let's throw that part out, let's throw that part out, because the entire ordinance is really the one that is affecting our client. I don't think you can chunk one out and save the rest in that sense. We'll get rid of the curtilage, but don't allow them to go into the house. So again, the evaluation as far as
So is it your argument that he should have more protections because this was in a familial relationship?
No.
He had been involved in a non-familial relationship?
No, what I'm suggesting is that, or what I'm saying is that the literature and the studies that have been done subsequent to a lot of the passage of these, the sex registry laws around the country, first of all, there's a lot of rethinking in the field, okay? And I would also suggest that even though the city adopted the predicate for the sexual offender registry as part of their basis for saying this ordinance should be in place, times change, okay? And our expert has testified in deposition that, they're really rethinking this whole thing, especially because the studies have shown such low recidivism. The studies have also shown that it's intrafamilial. That's all I'm saying, not that he should have some kind of, permit because, this is not in a family situation, but it's intrafamilial. Times have changed, recidivism rates are low. Our client is simply not dangerous. Okay, it's as effective as that. Those things, and yet we did not get any kind of an evidentiary hearing below to be able to present those things. The fairly recent case from the Florida Supreme Court related to homosexual adoption, okay, that we cited in our brief, shows that even with a rational basis test being applied, an evidentiary hearing is appropriate. And we asked for that below. We did not get it. The judge pretty much decided everything based on her interpretation of the law. So 4 of our issues, we argue, regardless of which of the constitutional tests you adopt, rational, intermediate, or strict scrutiny, based on various arguments we presented, were deserving of some kind of an evidentiary hearing. Let us go back and show that things have changed since 1997 or whenever the initial sex registry laws were actually implemented in Florida, and even since this particular, since perhaps there was thought given to this particular ordinance in the city of Palm Bay. Because they have changed, we're saying very strongly that this should be revisited, and there should have been testimony taken at trial. There should have been an opportunity for cross-examination on the part of the city. Basically, we did that through deposition. We did present and file that, but that's not quite the same thing, as you know, where you're presenting something like that in front of the judge. Yet that did not occur. We are also confident that if it had occurred, obviously that our client would have prevailed in being able to demonstrate that there was insufficient reason, whether it's rational, intermediate, or maximum scrutiny that you're looking at, to actually adopt this particular ordinance. And there's just a few other things, perhaps, before I concede. I have said that times change. We have a bit of an argument, no, we don't have a bit, we have a strong argument in terms of substantive due process that relates to interference with intrastate travel, which has been recognized in the JT case here in Florida and several other ones. Family association as well. We have the Burnett case where there was interference with interstate travel, all predicated on an Ohio ordinance that is kind of similar to ours. In Ohio, if you were a drug offender, you couldn't go into what they call certain drug-free zones. And 2 people challenged that ordinance, one at the state level, one at the federal level. In the, if I recall correctly, the state challenge resulted in a finding that it was in violation of their right to intrastate travel, and it was actually, that case was actually cited in our law here in Florida, the Ohio state of Burnett, the Ohio case of Burnett. And then in the federal Sixth Circuit, Johnson, they said it was not only interstate travel, but also associational rights. Okay, now how does association rights or family association come in here? Grandmother challenged it, said, I can't travel, I have a drug offense, I can't travel into drug-free zones because of that offense, so I am not available to assist in the nurturing and upbringing of my children. That, to me, does not differ than telling a person who has been supporting his family as an independent contractor with a plumber's license, okay, that, to me, is a direct parallel where he is going out there earning a living in the best way he knows how to support his family. As we all...
Rebuttal time, you're down to about a minute if you want to save it.
I will close and take my rebuttal. Thank you very much.
May it please the Court, Pete Sweeney, Deputy City Attorney, on behalf of the appellee, City of Palm Bay. With me is my co-counsel, the City Attorney, Andrew Lannon. Panel, I'd like to start by first going to the question that Judge Evander directed, and actually I want to predicate 2 specific facts as part of the record that are appropriate to bring up, one highlighted necessarily by the appellant. First is, of course, that the appellant pled nolo contendere to the assault charge, and that subsequently led to the sexual offender designation. Now, subsequent to that, the ordinance then applies, and that'll weave into my argument why it's not simply something related to the underlying charge, but in fact is simply resulting from his status of being a sex offender, which is virtually what all of the case law in Florida says passes constitutional muster in Florida, both at the federal and state level. But secondly, and perhaps just as importantly, is the ordinance itself. And when it was passed, there are 13 whereas clauses within the body of the ordinance. Now, I submit to you that's important because at any time, the rational basis test, which I believe is the appropriate review standard for this court, any of those, and in fact, exempting all of those, could provide the constitutional muster to meet the rational basis standard to find that this ordinance is in fact valid.
What sort of evidence was the predicate for the whereas clauses? What evidence was considered by the city? Or is any evidence required, or can they just pull the whereases out of thin air?
I think the answer is yes, there was evidence in the sense that when it was adopted, Your Honor, they reviewed the Florida statute and effectively copied those and embodied, in fact, I think verbatim, the findings of the Florida legislature on the issue related to the state statutes for sexual predator and sexual offender. But separate from that, I think the end of your question is even more important. There's no requirement whatsoever. And in fact, I think that the cases such as the Supreme Court's case in DOE v. Moore, U.S. Supreme Court, as well as the FCC v. Beach Communication, if there's any conceivable basis, even if not found and stated in the wherefore clause or during the legislative duty of that body, if there's any out there that could provide the rational basis, then the ordinance should be upheld. And in fact, the burden is on the appellant to disprove that there is really any reasonable conceivable basis, Your Honor.
The reliance on the state statutes on sexual offenders and sexual predators, was there any part of that was pulled exclusively from the sexual predator statute as opposed to the sexual offender statute?
I can't say for certain because I believe that the statutes are certainly separate, but they're in the same area. I believe it's 943, Your Honor. But even if there were, to go to your question, even if they were commingled, so to speak, between the sexual predator and sexual offender, I don't think that would matter because it wouldn't impugn the sexual offender if he were to use just cut off, excise the findings of the sexual predator, because even if there were no findings whatsoever for this legislative body, the City Council for the City of Palm Bay, that's not necessary. And in fact, when council cited to the case that's currently just recently been upheld, I believe, by the Florida Supreme Court regarding the fact that there's a rational basis when it comes to adoption based on sexual status, sexual orientation, they said that it had in fact been proved that there was absolutely zero based on the proponent in that case. There was no rational basis whatsoever, and they had actually proved that. Here, the burden is still on the appellant, and I don't believe there's any, first of all, evidence, second of all, any argument made in this record on appeal that supports that not only are the basis that the City of Palm Bay put forth rational, but that even if they are irrational, that there's no other rational basis out there.
Did they have an opportunity to present evidence on that?
Did the appellant have an opportunity to present that at the lower tribunal, Your Honor? Okay.
You just said there's no evidence, but were they given an evidentiary hearing to be able to put evidence before the trial court?
No, but that's not, the reason that I suggest that they didn't put evidence forth on that issue is because it's a red herring, Your Honor, and the reason why is that even if they put forth going to the presumptiveness of danger, the procedural due process aspect, whether or not they could put forth evidence that this particular individualized appellant is dangerous, or that the findings of the City Council, or lack of findings, quite frankly, of the City Council in passing the ordinance, it doesn't matter whether there's an evidentiary hearing or not. We do have a record, and they put forth affidavits, and there's an acceptable record of what potentially could be evidence in the case as the standard for summary judgment. But in this case, they weren't preempted from doing that. In fact, we have the deposition of their expert who suggests that he's not dangerous. But that presupposes that there's allowed to be an individualized determination. And the question previously asked by Judge Evander, I believe, regarding specifically the Connecticut v. DOE case, a U.S. Supreme Court case, is buttressed even more importantly by our Florida Supreme Court's case in Milks v. State, which very specifically went to the issue of individualized determinations of dangerousness and the fact that there is no procedural due process due after the initial claim. See, what's really being said here, the appellant is claiming that he's entitled to a second bite at really being designated a sex offender. And the fact is...
Talk about that, though.
Yes, sir.
The state legislature has put different requirements on sex predators and sex offenders.
Yes, sir.
And they very specifically prohibited sex predators from going to playgrounds and schools and places like that. They specifically did not do the same thing for sex offenders. Why doesn't that preempt, I mean, why doesn't that demonstrate that the state has determined that sex offenders should not be subject to the same sort of limitations as sexual predators?
First of all, there's two answers, and to answer your question specifically, there's three levels of preemption under Florida law recognized. Of course, there's explicit preemption, there's implicit preemption, and then there's whether or not compliance with both the state statute and the ordinance would be contradictory, and therefore the state statute controls. The question, is this explicit preemption? And I don't believe so. This is not akin to the most recent example that I think probably is most readily recognized is the area of gun control, and that virtually all gun control has been taken away and specifically reserved to the state, and very explicitly in the statute. Even though I agree that the sexual predator statute uses the exact same language as what we're talking here, there's no explicit language saying that municipalities or counties shall not legislate in this area otherwise, and in fact, the Calderon case has pretty specifically said, I believe it's the Calderon case, I apologize if I misstate, that you can also have other restrictions, which that case, if I remember correctly, talks about legislative, local municipal ordinances regarding distances that individuals can live away from schools. Again, the state statute specifically says, I believe, 1,000 feet. Most of the cities down south have said 2,500 feet, and generally speaking, I believe that's past constitutional muster based on that standard. So now we move to, is it implicit? Implicit, Your Honor, I just don't think so, and the reason why is the case law here is strictly construed, first of all, and second of all, it really has to be an area where they, quote, take the entire field. The most well-known, of course, is the Tribune case with the area of public records under Chapter 119. That's simply not the case here. As I just mentioned, there are multiple ordinances regarding sex offenders and sexual predators, regarding residency requirements in many of the cities throughout the state of Florida. So now we move to the third area. Can you be in compliance with both the state statute and the local ordinance? And if so, then there's no preemption whatsoever. Yes, you can be. Mr. Doe can be in compliance. He's not a sexual predator, as everybody in this room recognizes, so that part of it doesn't even apply to him. Can he be in compliance with the local ordinance by not going to these very limited places, I might add? He can still work. He's still a plumber. He still does quite fine, as he said, quote, in his deposition. He can work virtually anywhere else in the city except for these limited places.
So let's talk about the limited places.
Yes, sir.
The ordinance, when I look at the exact language, it says basically if you're a sexual offender, you can't go to a variety of places, and one of which is any dwelling, domicile, or other place where children or other vulnerable adults may reside. Well, I mean, isn't that every home in Palm Bay? I mean, a child may reside in any home. Whether they do reside is a different question. A child may reside in my home. My kids are grown and are out, but may suggest, is it possible for a child to reside in the home as opposed to, does a child actually reside in the home? Isn't the ordinance overly broad in the sense that if your goal is to protect children or vulnerable adults, shouldn't it say if a child does reside there or a vulnerable child does reside there? Because the answer, wouldn't you agree that the wording is any domicile, any residence where a child may reside, Well, a child may reside presumably in any home, any residential home in Palm Bay.
I think the short answer is that yes, it probably could have better language, but why is it still past muster is because of the fact, I think that the appellant's own deposition reinforces the fact that he has made that determination and therefore it's not ambiguous to him. He continues to work in Palm Bay.
Well, but I'm just focused on the language of the ordinance. Do you agree that that a child may reside in any residential structure in Palm Bay? Not necessarily does reside,
Potentially,
but a child may reside.
Potentially, yes, Your Honor. I agree that a child may reside in any structure in Palm Bay, but to give the ordinance a fair reading, as you continue to look down, and again, reinforced by the record that we have here on this appeal, that it's not simply every single house. He hasn't claimed that he can't work at every single house. In fact, it hasn't stopped him to do that.
But I'm just looking at the ordinance itself. I'm coming in, I'm a plumber, I don't know anything about Palm Bay or how you enforce your ordinances, and I'm just looking at the ordinance, and I say a child may reside in any structure, in any residential structure in Palm Bay. So doesn't that, if I read the ordinance, just give it a plain reading, not how your people choose to enforce it, but just a plain reading of the ordinance, doesn't it preclude me as a plumber, if I'm a sexual offender, which I'm not, or a plumber, doesn't it preclude a plumber who's a sexual offender from working in any residence in Palm Bay?
Potentially, yes, Your Honor. But to dovetail on a question that you asked appellants, which I was answering for this line of questions, which had to do with preemption, you had asked appellant, isn't that fundamentally a different argument than you raised, which had to do with the application of the plumbing statute, Chapter 489, and really whether that field had been preempted. And in fact, it's kind of interesting, they actually, in citing it, Chapter 49, Section 49.113 specifically says this subsection does not affect the application of any local construction licensing ordinances. So it's kind of interesting. The statute they rely on actually specifically says there is no preemption.
Could the city of Palm Bay, for example, under their preemption argument, could the city of Palm Bay require, for example, additional continuing education requirements for plumbers beyond what the state requires, or require certain uniforms? Plumbers have to wear certain uniforms when the state statute doesn't require that.
I would say an analogy would potentially be, say, require additional insurance. And I would refer to the Supreme Court case, Phantom of Brevard, in which they found that the Brevard ordinance that required an additional $1 million in liability insurance for fireworks sellers was above and beyond the required minimum $500 bond that would be applied. And so I would make an analogy, and that was found to be not preempted.
So the city of Palm Bay, using that analogy, the city of Palm Bay could, for example, say that any attorney that practices in Palm Bay has to have 100 hours of continuing education a year versus what the Florida Bar or Florida Supreme Court requirement is. And your view is that that would be okay?
No, Your Honor, because I believe the case law is slightly different there, and again, now you're talking about potentially separation of powers.
All right, well, let's take a different one, based on the Phantom of Brevard. For a doctor to have hospital privileges, they have to have certain minimum insurance requirements under state law. Could the city of Palm Bay say, you got to have twice whatever the state law requires?
Again, Your Honor, I think that's a different situation because without being intimately familiar with the licensing of medical providers in the state of Florida, I think that area is probably more likely completely preempted, whether exclusively or implicitly by the state. So I think that local ordinances would be preempted by state statute. But even more importantly, going back to your potential vague and ambiguous argument, Your Honor, that argument has never been raised by appellant in this case, the reading of the may language. So I want to be clear based on the record we're here on. And very importantly, I want to go to the application of ex post facto and whether or not this is a criminal potentially penal ordinance or not. And most importantly is going to the Supreme Court of Florida's case in Griffin v. State, the 2008 case. This is a conjunctive test. And test one of the prong is the law retrospective in effect? I think that the U.S. Supreme Court said it most appropriately when they said, when you're asking that question, does it punish as a crime an act previously committed which was innocent when done? There is no aspect of this record that suggests that anything the appellant did prior to the enactment of the ordinance in 2005 is being punished. Nothing. No job he did, nowhere he went, nothing. It's only subsequent to that date, if he goes to one of these places and performs work, would he potentially be subject even to this ordinance. I think it fails on the first prong alone. If you then move on, potentially, and it's a conjunctive test, to the second prong, does it alter the definition of criminal conduct or increase the penalty? No. He's not being punished for the probation or any of the traditional aspects of punishment that we recognize under the 7 factors of Kennedy v. Martinez-Mendoza. I can go through those, but I believe most appropriate is to go to the U.S. Supreme Court's view of those factors in the Smith v. Doe case, which they looked at the Alaska sex offender ordinance and almost uniformly found that all 7 of those factors militated in favor of finding that it wasn't a punishment, a penal statute. In fact, it passed Martinez-Mendoza.
That statute had criminal penalties? The Alaska statute, like this does?
By failure to register as a sex offender. Your Honor, I don't recall off the top of my head.
I mean, in this case, it is defined as a misdemeanor. It has criminal penalties attached to it. Isn't that pretty significant in deciding whether it's a criminal statute or not?
Potentially, yes, Your Honor, but you have to look at all 7 of the factors, and none of the singular factors is determinative. Absolutely. And when you look through, probably the most important one is what they say, is there an alternative purpose? That's factor 6. And quite frankly, there is. In fact, it's actually conceded by appellant in his initial brief at page 15 that there is a reasonable, rational alternative purpose. It's the health, safety, and welfare, the touchstone of municipal law and the powers of municipalities to regulate in areas that are not specifically or implicitly exempted by state statute.
Florida makes it a crime to fail to register, correct?
Yes, sir, Your Honor.
Case law on that?
If you fail to register, is that a crime? Well, yes, Your Honor. I mean, the fact of the matter is, sex offenders are not, again, going to quickly, the equal protection argument, are not a suspect class, and the fundamental right, if there is one at all, theoretically implicated here, they've argued, and I think Judge Davidson said it very, very well in the lower order, is that appellant is claiming he's treated differently from other similarly situated persons, providing labor in places where children or vulnerable adults are present. In short, appellant is claiming his right to work is a fundamental right. First of all, no court anywhere at all has recognized a fundamental right to work. The other rights that they've talked about, the right of family association or the right to contract, well, under the right to contract, there is nowhere in this record that there was a contract in place that's necessary to find an impairment of contract under federal case law on this issue. Under family association, it's really a stacking of inferences. He's suggesting that he can't provide for his family, but he can work, he can do all of these things, and the right to travel, I'll get to in just a second, but going back to that specific issue, is there punishment already associated with failure to register? Yes, absolutely, Your Honor. If you fail to register under Florida statutes, you potentially are subject to incarceration or other penalties associated with this. But the key here, really the key in this entire case, is that this is application of a status, and it's only that. It's just application of a status. It's not any type of penal status based on a prior criminal act. It's simply application of a status, just like virtually all of the Florida courts have already found, passes both federal and Florida constitutional law. Virtually all of the cases cited by appellant in this case that have found different from Smith v. Doe or Doe v. Moore are state cases applying state constitutions. So based on that, we ask that this court uphold the finding of the lower court. Thank you very much. Yes, sir.
Deal with the excessiveness. If Palm Bay made the ordinance apply to any business where children or vulnerable adults may frequent, would that be okay? And when do you reach the level of, in essence, a banishment?
Well, I think, again, it goes back to, I'm not sure, but fortunately, at this point, based on our record, and the idea that the legislature doesn't have to be perfect in finding its solution to this aspect. Yes, is there a threshold at some point? Yes. In every case, there's a threshold at some point. But the decision that this city council made to word it this way, at this point, I believe, based on both federal and Florida law, passes constitutional muster. So, in a different form, potentially we have a different case. But as we sit here today, I think it's fine. Thank you very much.
Thank you, Council.
Thank you, Your Honor. Just for a brief rebuttal, we would like to, again, revisit the fact that, and remind the court that when you talk about residency requirements as a kind of another analogous sort of restriction on sex offenders, the residency requirements have been upheld on the basis of their grandfathering. If I live as a sex offender within the distance, I don't have to move. They can't force me to do that. I'm grandfathered in, so it doesn't have an ex post facto, if you will, or retrospective application. When we did depositions, and again, this is urging the court to consider on a number of our counts that there should have been a hearing on it at a minimum. But when we did deposition, the city could offer no evidence that this ordinance was effective in any way.
Let me ask you this. Your opposing counsel stated that there's no case law recognizing a constitutional right to work. Would you agree or disagree?
I would agree with that, but not necessarily the constitutional right to contract, okay, or for family association, or for interstate travel, all of which we have combined in our substantive due process argument. The last couple things, Alaska, you referred to the Alaska case as far as ex post facto is concerned. That has been overturned by the Alaska courts. They found it to be ex post facto in a subsequent case. And finally, as far as one thing for the court to consider, I would pose the question of what would happen if this ordinance went statewide and what would the outcome be. I frankly think that the Supreme Court of Florida would predictably declare it unconstitutional because of its interference, particularly because there's no hearing on this. There's nothing to substantiate that this particular ordinance has a foundational purpose that can be supported. Thank you very much.
Thank you, Council. Next case on the